specifically found were owned by a separate, non-party corporate entity, Furious Properties, LLC. Second, the trial court erred by appointing a receiver over assets owned by Furious Properties, LLC, when the entity itself was not a party to that proceeding, was never provided with the required statutory notice, and the wife's motion never sought such appointment over the entity's assets. Finally, the third issue, the trial court erred by granting the divorce as to irreconcilable differences between the parties, where there was no written agreement as is required by statute,
from the Tennessee
and the parties
Supreme
had
Court
stipulated two grounds for divorce instead.
Divorce.
Turning to the first issue, Your Honors, the important distinction that the trial court failed to make is that assets owned by an LLC are separate and distinct from assets owned by its members. A spouse's membership interest in an LLC may properly be considered marital property and awarded to either spouse, but assets titled to the LLC are the separate property of that LLC and cannot be included in the marital estate. Your Honors, the LLC is not a party to this case, yet the court has ordered it to divest itself of its own property. Respectfully, the trial court cannot order that entity to do anything without establishing subject matter jurisdiction. We are asking this court to declare the property titled to Furious Properties, LLC as separate property and remand the distribution of the marital estate to account for this classification.
Your client was the sole member of the LLC?
No, Your Honor. My client testified that his father was the sole member of the LLC, and that's the only proof in the record as to the ownership of that entity.
Trial court say anything about that?
The trial court concluded, based on the receiver's report, that Mr. Sexton owned the entire membership interest in the entity and then proceeded to sort of contradictorily award the assets owned by that LLC to the wife. Our argument is that
but the trial court found that your client was the one who really owned the LLC.
That was the trial court's finding, Your Honor, and our argument is that the evidence preponderates against that finding.
Yes.
Your Honors, the relevant statute for that is TCA Title 48, Chapter 249, Section 502, and it specifically provides a membership interest in an LLC is personal property. A member has no interest in specific LLC property. All property transferred to or acquired by an LLC is property of the LLC. And I'll remind this court that both parties stipulated and the trial court found that Furious Properties, LLC was the title owner of these real estate parcels in question. And despite this undisputed finding, the trial court proceeded with its contradictory order, which our client is left facing an unenforceable order. He can't comply with it, even if he wanted to, Your Honor. Second, there are only two sources of evidence in the record as to the ownership interest in Furious Properties, LLC. The first was the receiver's report, which mistakenly assumed that Mr. Sexton was a 50% owner, along with some other unknown party. And the receiver admitted that he reviewed no corporate documents in making that determination, and he made that assumption based on Mr. Sexton's payment of property taxes for the entity.
Hey, y'all, how you doing?
But ultimately, the receiver admitted at trial that the issue of ownership for this entity would have to be determined by the remaining record in this case. He conceded that issue, and the only other evidence before this court was Mr. Sexton's uncontroverted testimony that that owner was his father. Mr. Sexton also testified that his father paid for certain expenses of the entity, and
I'm sure you guys have
Trial Exhibit 1, the pretrial stipulations include attachments to some tax deeds where Mr. Sexton's father signed the deeds on behalf of Furious Properties, LLC.
Well, I mean, the trial court made other, when you say there was no evidence other than what your client testified it was his father, I mean, the trial court went through and looked at a lot of other things, didn't he, and made findings such as your client used his personal funds to buy the property. He personally organized and maintained the LLC. His husband further spent personal funds to renovate and repair the property. I mean, so the trial, it's not like the trial court just didn't look at any other evidence, did it? I mean, I understand you may disagree with the findings, but at least the trial court made findings on that, didn't it?
Your Honor, that's correct. The
Garland
trial
must have been a
court
matador in
considered
the previous life.
Mr.
Oh,
Sexton's
man.
tangible and intangible contributions
Brandon, I ought to
to
check
the
that out
LLC as evidence of his ownership, and that is not sufficient to establish membership in an LLC. The authority wife cites in her brief supporting that argument actually suggests that tangible and intangible contributions to an LLC are not sufficient by itself to determine ownership,
So what you got here is there's a husband and wife getting
especially
divorced,
not in a case where
and they are
the
trying to decide
purported member
who
is
gets
not asserting a
control
membership
of the
interest
company.
himself. Mr. Sexton has never claimed to be a member or an owner of this entity. The wife is asking the trial court to impose membership status on him in a proceeding to which that entity is not a party, and grant Mr. Sexton all the rights, privileges, and duties attendant with membership status
Let's go.
on that
You're
entity.
awesome, dude.
Now, there's no precedent for that argument, and the trial court did adopt the stipulation of the parties that the title owner to those tracts was, in fact, the entity itself. But, Your Honor, even if this court did find that a marital interest in the LLC exists, the trial court still lacks the necessary subject matter jurisdiction to award the assets owned by that separate legal stranger, the entity, award those assets to
Blue
the
Dog wants
wife.
a Pop-Tart.
The only way you can do that is if you pierce the corporate veil. That analysis was never undertaken in this case. There was never alleged any of the Allen factors, and that issue was not raised at trial.
So Tennessee Supreme Court.
The next major
division
issue
of Tennessee,
that we want to
West,
raise is
Middle, and
that the trial court erred
They
in
remain
appointing a
in
receiver
East Tennessee
over
and
the assets
Knoxville to be.
of Furious
what the
Properties
paper-
LLC in a proceeding in which the entity itself was never given any notice, never had an opportunity to be heard, and the receivership proceeded to investigate and determine the ownership interests of those properties. And the statutory requirement, it's Section 103 of the Uniform Commercial Receivership Act. It applies to all proceedings in which a receiver is appointed
UCC.
that affects an interest in real property. That's this case, and in Your Honor, certainly Furious Properties LLC has been biased by the award of its separate assets to the wife in a divorce to which it's not a party. It's also worth noting that the wife's motion for receivership never sought a receivership
happened here?
for
We're
Furious
in divorce?
Properties LLC. It was originally sought to manage assets of the marital auto salvage business, and then the trial court, on its own initiative, expanded the scope of that appointment to investigate the properties held by Furious Properties LLC. And straight
Who
away,
gets,
the receiver was
let's
confused,
go.
perhaps understandably,
You got
about the
Let's Go
two
TCU's
distinctions
Kids,
between
Miami?
Furious Properties LLC and the similarly named
What's wrong with
Furious
his hair?
Investments
He looks like the
LLC.
guy from Community.
His first report mistakenly switched up the names, and later he acknowledged the oversight. He supplemented his report along with his mistaken assumption that Mr. Sexton was a
Wish it said
50%
who the
owner,
attorneys were.
an assumption that he ultimately conceded was not grounded by any basis in fact. The improper appointment of the receiver without notice, without an opportunity to be heard, and the trial court's reliance on his
He looks like a
testimony
young
has
Tom Brady.
inextricably shaped
This guy,
the classification and valuation of the marital estate. And we ask this court to remand the trial court's distribution to account for the properly classified separate property.
So these guys, like this
Finally,
guy
Your
here,
Honor, the
he just got out
third
scored
issue we
not long ago,
take
it looks
issue
like.
with is the trial
And the way
court's
he speaks,
error in granting the divorce as to the grounds for
has to be written
reconcilable
down.
differences.
if
The parties had
maybe get it
stipulated
uphill.
two grounds for divorce
But,
pursuant
yeah,
to
trial court,
TCA Title
get
36,
someone like
Chapter
me
4,
who sits there and
129.
just talks in
This is a
nonsensical
separate
ways.
grounds for divorce than
mess them up
irreconcilable
very
differences. It allows the court to declare both parties to be divorced rather than awarding the
I don't
divorce
care
to
what
one party on fault-based grounds.
I have a
The parties may stipulate to one of the fault-based grounds, or the court may simply declare them both
I
to be
hope you are
divorced
having an amazing.
if they are both entitled
Thank
to
you.
it. These parties stipulated to divorce,
need
and
an
the
amazing
court
day. I need a win.
recognized that stipulation before
win.
sort of summarily granting the divorce as to irreconcilable differences. This error didn't affect the distribution of the marital estate. It presents really only a technicality, but it is a clear error that we are asking this court to remedy by vacating the trial court's grant of a divorce as to irreconcilable differences.
So you hear that? How'd you like to
and
be
declaring the
divorced,
parties
and
to
then
be divorced,
you
as to
appeal it,
stipulated
and
grounds
it's no longer
pursuant
divorced?
to TCA 36-4-129.
So what happens then if you were out there
Your
going
Honor,
around
where we are
having
left is that
sexy
the
time
trial court has ordered
in the
a
clubs,
separate
You
legal
now,
entity who had no notice of these proceedings
committed adultery?
and ordered it to divest itself of its property. It was undisputed at trial that the assets in question were owned by that entity. The trial court's mistake has left us here on appeal. We're asking you to remedy that error, and I'm happy to answer any more questions.
I hear none.
Thank you.
You have your time for rebuttal.
Thank you.
Hear from the
Because they
applicant.
messed up in the divorce. I see who this guy is.
May it please the court. Judges, Chad Tyndall on behalf
Yo,
of
Chad
the appellee
Tyndall.
Louise Sexton. Also,
Hey, Chad, how you
Michael
doing, bud?
Franz,
Chad's
in my
a good
office.
guy.
I should note that I tried this case in the court below and had a long, somewhat history with this case. Mr. Franz wrote the briefs, and he should be acknowledged for that, for the good work that he did, and I appreciate
Chad
that.
shaped into an old-time looking
If the court please,
Tennessee lawyer. This should be good.
I'm going to deal with the issues on appeal that have been raised by the appellant somewhat in reverse order from their brief, because I think that that makes somewhat the most sense. And that is first, the grounds for
already put the
divorce.
lawyer
If you
down.
look at the court's judgment below, the first statement in the findings and facts said the parties announced at the beginning of trial that they had agreed to stipulate grounds for divorce pursuant to Tennessee Code annotated 364129A, and the parties shall be granted a divorce accordingly. For some unexplained reason,
Baker, what's
at the
up?
bottom of that
Yeah,
paragraph,
it's sex
the
time.
chancellor then said
This
that
is a divorce
court
appeal, man. This is
grants a
Tennessee.
divorce based on irreconcilable differences. I don't know the reason for that, but I would believe it's within the purview of this court that you can correct that somewhat technical error that the court found that they stipulated. The parties did stipulate, and I think the record supports that the parties stipulated that they would be granted a divorce or stipulated grounds for divorce. With respect to the appointment of a receiver, the appellant cites the statute or the Receivership Act, and while called a receiver in the context of this case, the receiver was not really a receiver in the context of the same statutory scheme where he would be given the right to manage, sell, do all these things with the properties. The order entered back as a result of the June 2, 2022 hearing. The order that was entered and approved by all counsel
Baker,
and Mr. Newton
this
as the
attorney talking
receiver,
right now, I
that was
actually know
the
that guy.
amended order which
He
added
doesn't know
the
me,
two
but I
Furious
know him.
investments and Furious properties. Merely asked merely asked the
I knew him when he was a...
receiver to investigate the properties. But I think it's critical for this court to look at, and that's one of the things that I'm going to continue to say throughout my argument, is that you have to look at this case a little bit larger and look
Caitlin,
at the
how's it going?
context in which this happened. And that is this. The
Todd, how
appointment
you
of a
doing?
receiver, called a receiver but not really a receiver, was necessitated by the fact that Mr. Sexton refused to cooperate in discovery. If you look at the record of this case, there were numerous motions to compel, motions for sanctions because he would not divulge records, he would not provide discovery,
What's my drink?
and so we had to go to court and ultimately had to appoint someone, in effect, probably more appropriately named a special master, to investigate and provide the court with information such that the court could make some determination
master.
as to the assets that were there and make some determination of ownership and then a division. The court did that, and I think that though called a receiver, I don't believe that the receiver in this case was technically a receiver under the Act. They were given very specific duties to go and report back, which he did, his findings about what properties that Mr. Sexton may own, what interest Mr. Sexton may own, and what title to the properties. The last issue, and that is with respect to Furious Properties LLC. Furious Properties LLC, the receiver did report back, and the court found, and frankly the party stipulated, that the title to the two properties, Judge Sweeney was correct in pointing out that
Judge
this was a
Sweeney?
sole one-member LLC. Mr. Sexton at trial claimed that it was owned by his father. This was an LLC that Mr. Sexton, the appellant, organized, filed the documents, did every single thing that was necessary with respect to establishing the LLC during the pendency of this divorce, and caused these properties that he bought with his personal funds, marital funds, caused these properties to be titled in the LLC's name to, in our view, separate them or maybe put them out of reach of his wife. And in doing so, that created a problem, because then we have to determine, because in the LLC we have to determine, and the court then, in its opinion, considered many different things. I know that the consistent thing that we hear is that the only evidence was, or the sole evidence was Mr. Sexton's testimony, his own self-serving testimony as to, oh, well, that's my father's. But this also has, and I mentioned it before, this also has to do, and I think you have to look at this within the context and the backdrop of this case. Throughout this case, and I mentioned it before, that Mr. Sexton refused to cooperate in discovery. It was very difficult in getting information. In addition to that, testimony was, and there was evidence produced. There were a number of family businesses that Mr. Sexton was involved with, one of which was an auto salvage business. That's not necessarily here to be discussed as far as a division of property or an equitable division, but there was an auto salvage business that he ran for many years with his brother. It was run on property that was owned by the family trust. Mr. Sexton's mother was the trustee of the family trust. Mr. Sexton's mother filed suit against Mr. Sexton and his brother after some 20 plus years of never collecting rent. Suddenly the claim was made during the pendency of this divorce that Mr. Sexton's mother and the family trust was entitled to rent, which would give her a lien on the assets. When we became aware of that, there had already been scheduled a sheriff's sale that we were able to stop that would have seized all of the assets of the auto salvage business, which would, in our view, and which frankly, if you look at the opinion, part of which were granted to, my client had an interest in those, because that interest in that ownership interest was developed over the many years of the marriage. And so the efforts were made to file this lawsuit. Well, Mr. Sexton testified at trial that he never talked with his mother about this lawsuit. He never put up any defense against it. He never put up any defense against the other lawsuit that his mother filed in Knox County against both him and his wife, Miss Sexton, my client. Well, when you look a little bit closer, well, it would be different if these parties were somewhat estranged from each other. Well, they weren't. He testified that he had a good relationship with his mother. He just so happened to never discuss owing some $136,000 in rent or this claim that had not been made. And the other thing that I would emphasize to the court, when you look at this, Mr. Sexton lived with his parents, took care of his parents. Yet the court was expected to believe that he somehow never discussed it, it never came up. Well, that's just the way it is. It is against this backdrop that you have to look at the record as a whole and Mr. Sexton's credibility and testimony at trial. When he testifies, the properties from Furious Properties, LLC, the two Knox County properties that are the subject of this appeal, when he testifies, those are my dad's. But his dad doesn't testify to that. He offers...
Let me ask you, counsel. I mean, the LLC was not a party to this lawsuit.
That's true.
And there's, at least from what's in the record, there's another individual that claims to be the owner, apparently.
Well,
According to the husband, his father is the owner. And I understand the trial court found otherwise.
yes.
But, so how does the trial court order the LLC to transfer these properties?
Well, and that's a very good question. And,
Thank you.
I believe that what the court did was embark on an analysis to determine who owned the interest in the LLC, not just the real
The
properties.
trial court didn't do that, though, did it?
Well,
It didn't award your client whatever husband's interest in the LLC was.
I believe that is correct, and I believe that under the statute, this court has the ability to reform and revise that decision under the statute. But when you look at it, after doing all of the analysis concerning the fact that the husband bought the properties with his personal funds, testified that his father never paid him back, testified he made repairs, did all of these things, did everything to organize the LLC when it became defunct. He was the one that did all these things. But then when the court went through all of the analysis and consideration of all of these facts, the court determined that the interest in the LLC was marital property, was Mr. Sexton's and subject to division. In fact, if you look at the court's judgment, it says, based on all the evidence presented, the court concludes the entire interest in Furious Properties LLC is the property of defendant, Mr. Sexton, and his marital property subject to equitable division. So the court found that the membership interest was marital property. The court then, and I understand the appellant's problem with that, the court then ordered the LLC or Mr. Sexton to transfer the properties. that particular procedure may be incorrect. We believe that the court could order that, and did in fact order that, obviously, but this court has the ability, because if this case were to be sent back, if the entire judgment were to be overturned, the court could simply award the membership interest to Ms. Sexton. But we believe under the statute, this court can do that. If the court believes that that was an error to order that the properties be deeded over to Ms. Sexton, maybe simply the membership interest, which this court found after consideration of all of these factors, the trial court found that the membership interest was marital property. That is subject to division, and that's where you have a question as to how you get that property to Ms. Sexton. As I noted, the court focused a bit on the various factors, and we've cited to the court various case law that allows and specifies exactly how a court can determine who owns an LLC by the actions that they take, things that they do. Are they doing things consistent with a member? And once again, I would tell this court, Mr. Sexton brought not his father, not a document, not one thing to show that his father was the true and actual owner of any membership interest in this case, or in Furious Properties LLC. We believe the court correctly decided that Furious Properties LLC and or the assets therein were marital property subject to division. Maybe that's the membership interest, and the court should have ordered that the membership interest is what is marital property, because that's clearly what the judgment says. But we believe under the statute, this court can do that. Finally, Your Honor, the question is, and the appellate raised the question over an award of attorney's fees. We've requested attorney's fees as part of this appeal. You're dealing with Ms. Sexton, who took money out of her retirement to purchase a vacant land at a tax sale and put a camper on it. She has a job and earned an income, but Mr. Sexton testified that he had significant assets, earned a good income, lived at home with his parents, basically debt-free, and that the court found, based upon the fact that he had personal funds to buy these properties, that he had funds available, some of which he was never able to explain. He claims that he used funds that were from some source that would make them separate in the context of using those to buy these 2 Knox County properties, but never provided proof of that. In fact, when I cross-examined him, he could provide no explanation because I trust him. He showed the money going into an account, but 2 months later in an account statement that was introduced as an exhibit, the money goes out and we don't know where. Well, we believe the court made a correct decision with respect to attorney's fees, given all the factors that are relevant with respect to an award of attorney's fees. We think that decision was correct. We likewise think that Ms. Sexton would deserve an award of attorney's fees in connection with this appeal. I would be more than happy to answer any questions concerning Ms. Sexton's case.
How long was I on mute for? I just realized.
Thank you so much.
Thank you. Here's the appellant rebuttal.
Very briefly, Your Honors, regarding the last issue of attorney's fees raised
I was
by wife's
talking away
counsel,
about all this, and I think I was on appeal. Did
we
you
rely
guys see the thing
primarily
about
on our
Sexton
brief
Automotive?
for this issue, but I'll remind the court that the wife was awarded the majority of the marital estate in the disposition of the marital estate at the trial court level. The wife's separate estate, as awarded, dwarfs that of the husband's. She had somewhere in the neighborhood of $342,000 in separate assets, separate liquid assets compared to the husband's of around $40,000. And the majority of the non-liquid assets owned by Mr. Sexton are
mute the
co-owned
entire
by
time?
his brother. So Mr. Sexton does not have the ability to pay an award of attorney's fees, and we believe the merits of his case on appeal marshal in favor of an award for his attorney's fees. Wife's counsel.
I'm sorry. Did you raise the issue of attorney fees?
Nope.
Your Honor, we disputed the award.
You didn't raise it as a separate issue. I'm not talking about attorney fees I understand you raised that in your reply brief. You didn't raise as an issue attorney fees awarded to wife by the trial court, did you?
We did not dispute the award of attorney's fees to the wife at the trial court level, but on appeal we do, Your Honor. Regarding wife's counsel's
dispute
argument
and
as to the
appeal
receivership,
intensity,
that the
and
receiver in this
dispute in court
case
for it to
was
be
not
go
really a
appeal.
receiver, he was a special master. While it's true he
If I'm
exercised a broad array of powers pursuant to his order, wife's motion to appoint a receiver requested a receiver to be appointed over the assets of the marital auto salvage business, and the wife made a further motion to authorize that receiver to liquidate his assets. The trial court, by its own initiative, expanded the scope of his appointment to include the assets owned by the Furious Properties LLC.
Nancy, if it was error for the trial court to appoint what at least was called a receiver, how was your client harmed by this error?
Your Honor, I think the bias that has resulted to our client has been the trial court's the receiver's influence on the trial court's decision. He mistakenly assumed Mr. Sexton was an owner in this entity. If the entity had been, afforded proper notice and an opportunity to be heard, that would have been avoided. Certainly also, the trial court's reliance on the receiver's report has affected the valuation of the marital estate and the distribution of the marital estate, and my client's been negatively affected by that as well. These separate assets have been included in the marital estate.
Do you agree that the trial court made a credibility determination as towards your client and it wasn't particularly favorable?
Your Honor, I recall
Don't
that
you
the
love
trial
on
court
appeal
made
how
one
the
reference
judges
to my
are,
client's credibility discussing
ask correct
personal
questions?
property. And they noted that there was a discrepancy between his answers to interrogatories on the values of some guns and what he testified at trial. I think my client testified that he had meant to put down 1,000 instead of 10,000, and they found that to not be credible. The trial court relied on Mr. Sexton's testimony throughout its judgment, and so did the receiver, and they did not question his testimony on several issues, aside from maybe this personal property issue. Thank you, Your Honor.
Court's thanks to counsel for both sides. We appreciate your argument and your briefs on these issues.
From Mexican dragon fruit and water lily seeds
What's happening? Oh, that's the case.
to Miyazaki mangoes.
So there you go. That is a appellate court
ceremony-
case. Don't you guys love that? That is how short the whole thing is. See, 27 minutes. Now we got another one coming up.
May it please the court,
Oh,
I'm
look, here we
Janet
go.
Hayes. I'm here today on behalf of Knoxville HMA Physicians Management, and I'd like to reserve 4 minutes for rebuttal, please. Knoxville HMA Physicians Management operates through a subsidiary, a hospital. It is a hospital that at times pertinent to this case had multiple campuses. The 3 campuses the court may be familiar with were known as Physicians Regional, Turkey Creek, and North Knoxville. The issue before the court is the interpretation of the term hospital as used in the plaintiff's employment agreement. More specifically, the issue is whether
How
the
you
parties
doing?
intended for the term hospital to be the singular hospital HMA that operates 3 campuses. Pertinent,
Was the definition of hospital listed in the contract?
the contract, we have to look at the contract as a whole, and obviously that is going to be my argument. On the cover page of the contract, which is where the issues really arise in this
I haven't
case,
even
the
checked
term
the
hospital,
Discord yet.
next to it, it said Physicians Regional
so you guys
Medical
can say.
Center. This, if I may back up, this employment agreement that the plaintiff entered into was to provide services as a nurse midwife. The services, the employment agreement provided, the purpose was to ensure sufficient medical services available to serve the community. Plaintiff was represented by counsel and negotiated certain terms in the employment agreement. One of the terms that was not negotiated was Section 5.4 that offered up 4 potential, what I'll call triggering events, that if any one of these events occurred, the plaintiff would be entitled to 2 months' pay. One of the events was the cessation of material operations of the hospital. In 2018, the plaintiff received a notice that physicians, and the notice stated, the Physicians Regional Medical Center location would be closing. Based on that notice, she did not stay and see what happened when it closed or attempt to relocate to one of the other campuses. Instead, she voluntarily quit her employment and tried to invoke Section 5.4 and claimed that she was entitled then to 2 months' pay. That led to litigation, and there were other issues in the trial court, but the only issue that is being appealed, both sides filed motions for summary judgment on this issue in the trial court, and ultimately the trial court granted the plaintiff's motion for summary judgment.
How much money are we talking
Now,
about?
both sides will argue today some very fundamental principles of contract interpretation. What we are here to do is to try to determine the
Contract law.
intent of the parties at that time when they entered into this employment agreement. And we
hate when
submit,
that's your
if you look at the,
You have 3 campuses. One closes, the other 2 are still operating. Plaintiff is employed or works at one campus, the one that closes.
John McCarthy.
Now, in order for her to be subject to or qualify for this 3 month, was it 3 months? 2
2
months salary.
It don't last. How's it going, bud?
Would all 3 of the campuses have to close? The whole thing is to shut down?
correct. In the employment
been to Jack
agreement,
in the
what it
Box?
provided was if the
Dude,
hospital closed,
they still
if the
have their
hospital
tacos?
ceased operations.
But she was
Like
not
$1.
guaranteed
Get that.
employment
It's
at the other 2
crazy how good
campuses
they
that
are.
remain
Great,
open.
man.
That's
Hopefully
When
correct.
she
you're
was
like,
at
douche or
closed.
hungover.
In fact, the
Then-
notice provided to her says that she can seek
Tennessee
employment, but
turned
there's
out
no
to
guarantee she's going to get
get
there.
a.
That is
Fried
correct. She
chicken
could seek
sandwich used to be
employment at
like
one of the
$1
other
whatever.
campuses. It wasn't
Like I get
guaranteed,
which is
but
like
she
mustard.
could
I don't get like
seek
lettuce or like any mayonnaise.
to get a job at one of the other
Then you get a
campuses.
bacon cheeseburger.
But the
Take
fact
the
remains,
bottom buns
those
off
were
both, put them
3
together, you got
campuses
bacon,
of one
hamburger,
hospital. They were
and,
simply
chicken.
3 separate locations. And if you look at,
Is it your position then that that contract provision, termination without cause, isn't applicable here?
I'm sorry, I couldn't.
That the termination without cause provision is not applicable because all 3 campuses didn't close?
Correct.
What
That-
was their basis for firing her without cause?
She was not fired without cause. She voluntarily quit. When she received notice that Physicians Regional Medical Center location was closing,
Will
then she
have their-
turned in a voluntary notice
I'm
that she
sorry,
was
will have
quitting.
their employment permanently terminated on December 28?
She didn't, she quit before we got to that point.
There you go.
Well, they
But
sent
she,
the
yes,
notice,
I think
didn't
to
they?
your point, she did receive notice that the Physicians
Okay.
Regional location, she worked in the medical office of a doctor.
So she was told she was going to be terminated as of December 28.
Correct. Correct. The contract, if
Okay,
you
well, so
look at
what was your
her,
basis, what was the basis for firing her without cause? If this contract provision doesn't apply,
right. I
what
don't
was
think
the
the
basis?
issue is
Why
whether,
could they fire her without cause when they had a specific termination without cause provision?
I think it could be likened to a reduction in force. There was a closure of a campus. There was one entity
Okay.
that,
But your all's view is that it's all one deal.
correct. It is one hospital. It is one hospital that operates
So
at
but if
3
one
different
campus
locations.
closes, you can fire without cause.
We are just asking to implement the terms of the contract as it's written, and that section 5.4, that particular trigger is only invoked if the hospital ceases operations.
Well, if that clause doesn't apply, what contractual basis did your client have to fire?
Your Honor, the hospital, the campus, I guess you could
Well, I understand
treat
why.
it as a
I
reduction in
understand why
force.
they did. But you're saying this contract provision only applies if all 3 campuses close. So if you have a contract that has a termination without cause provision, and what happens doesn't fit under that contract, what's your client's legal basis for firing her?
I think you're asking
I'm not
to
asking why, I
rewrite.
understand why they fired her, because the campus closed.
Right.
What's the legal basis for firing her? You have a termination without cause, I keep saying clause, termination without cause provision, but your client's position is that clause does not apply.
Correct.
All right,
That
so-
provision does not apply. I guess the same question would be if all 3 locations
Well,
closed.
then my question would be, if that clause doesn't apply, what was the legal basis for firing her? I understand why they did, but what's the legal basis for firing her without cause?
I don't know that there is an issue about with cause or without cause. Her
Well, what's the
employment
legal
was-
basis for firing
This
her?
judge is gonna have a
Assuming
field
she
day.
was fired, and I understand your position that she resigned before.
Right, she was resigned. We don't know if she would have been fired, and she certainly would have had the opportunity to go to work as many other people did at
She
one
would
of
have had
the
the
other
opportunity to
campuses.
apply, pretty much the way any nurse would,
Correct. Correct.
but they worked for.
I think at the
All
time
right,
the parties.
I'm just trying to figure out if that clause doesn't apply, and you all have provided in a contract, here's when you can be fired without cause, and what happened doesn't fit there, what's the legal basis for being able to fire her?
I understand, Your Honor.
Okay.
The legal basis is what we have already discussed. There was a reduction in force. There were no jobs available at that campus. There continue to be other jobs available, and we simply do not know. We did not make it to the point, I guess, of her
She's
actually
kicking
being
the whole way.
fired. That didn't happen, and perhaps this would be different if we had gotten to December 28th. Then she may have been terminated, but in this particular case, she was not terminated. She was given notice that something was going to happen in the future, and she voluntarily quit. I think with regard to
That's
the
opposite
issue
what you said a
of
second
which
ago.
the
You
real
said that she
issue
was
is
fired
the
December
hospital. Is the
28th.
hospital a 3-campus system, or is it one entity? And
Excuse me for interrupting,
Certainly.
counsel. On that point, as I understand, the cover sheet identified the employer as Knoxville HMA Physician Management and identified the hospital as Physicians Regional Medical Center. And the applicable section of this agreement is cessation of all material operations of the employer and/or the hospital. How is that reconciled?
Physicians Regional Medical Center is simply an assumed name
what's
of
happening, I'm betting you.
HMA. Physicians Regional Medical Center has no assets. It doesn't exist. It doesn't have a legal identity
The hospital-
other than
Is that
as
part of the
HMA.
contract? Is that part of the contract?
She agreed to
Does
it,
it
and then all of a
address
sudden she called
assumed
them out.
names?
It does not address
realize
assumed
this could
names, but I would
affect
point out
all
the
of their
contract
employees.
does reference specifically the HMA bylaws and incorporates the HMA bylaws into the terms of the contract. If you look at the HMA bylaws, which would be a term of this contract, they say that the 3 geographically separated campuses are,
Yeah,
and I
that's what I told
quote,
you.
considered as one hospital with a single medical staff operating under one set of bylaws and rules and regulations. So the employment agreement that she signed incorporated these bylaws, and this is the most definitive statement we have on the issue.
Something.
And the bylaws specifically say the 3 campuses are one hospital with a single medical staff operating under one set of bylaws, rules, and regulations. And if you look at the other provisions of the agreement, if you go through it and look at all the references to the term hospital throughout the
Congrats, that's
agreement,
going, bud.
if you adopted the plaintiff's argument that all those mean Physicians Regional, then those provisions often would be rendered nonsensical. For example, there's a provision that that
didn't
same
write a
section
clear and concise
5.4,
contract.
if either party terminates
There's no
the
meeting of the
agreement, they can
minds.
terminate upon transfer of, quote, the hospital's assets. Well, Physicians Regional had no assets. Of course, it means the hospital in a broader sense. Similarly, the bylaws, or in the employment agreement, it repeatedly references the hospital's bylaws and hospital's board. Physicians Regional did not have bylaws. They did not have a board. So if you look at the entire contract and not one provision in isolation, it is clear that what the parties intended when they entered into the agreement was that hospital be a 3-campus system. As I'm out of time, I will, unless you have further questions.
Ooh,
You have
she
your
didn't
time
watch
for
her
rebuttal.
time.
Hear from the appellate.
Ooh.
May it please the court, my name is James Stovall. I represent the appellee Manola McCain. The parties do agree, I think, on one thing, and that is that the
Walter, you
issue,
know
the
these
sole
guys?
issue on this appeal is how to interpret a specific
Love the
definition
bow tie.
in Ms. McCain's employment agreement. And Judge Frierson, you were just asking my friend about that. Hospital in this agreement, and this is important, hospital with a capital H is a defined term, and section 1.1 of the contract says that capitalized terms shall have the meaning set forth on the cover sheet. So the case is really that simple. In a way, this is a case about case, as in uppercase or lowercase. The uppercase term hospital means Physicians Regional Medical Center. That's what the contract says. Contracts are enforced according to their plain terms. HMA is a sophisticated corporation. This contract was a form contract that it used with all its certified nurse midwives. The cover sheet is how it told those midwives what hospital they were going to be working in. It was HMA that chose to define hospital as Physicians Regional Medical Center. It made that decision. When a sophisticated party defines a term, that's the definition that's going to control, not some other definition. So, what about the bylaws? Let's talk about the bylaws. Yes, the bylaws were
You guys
incorporated by
excited about
reference. We urge the court to
I love
consider
these
the
contract
bylaws.
dudes.
The statement
it is.
that
They
HMA is
love
relying
contracts.
on
Fun with
about the 3
flags.
locations being considered one hospital, that's a small H hospital. That's a different document. It's not even in conflict with the defined term in Ms. McCain's agreement. It doesn't purport to override the definition in the contract.
Yeah.
And hospital in the bylaws is not a defined term. So yes, there is a passing reference to the 3 locations being considered as one hospital, but that doesn't mean they're one hospital for all purposes.
didn't know
It
that's his
doesn't
hobby.
mean that HMA can ignore the definition that it chose. So the 3 campuses, and what are we talking about when we say campus? We're talking about hospitals. Physicians Regional Medical Center is the hospital.
Well, what do you say, the opposing counsel's argument there that, look, a lot of this clause, or
I
cause,
knew Chad, but not this
clause, simply doesn't make sense. It talks about transfer of all, or materially all, of employer and hospital's assets. They say this regional doesn't have any assets.
It doesn't say. I think that, first, it's important to note that even in that clause, or especially in that clause, it's hospital with a capital H, not hospital with
hospital with a
lowercase
capital
h.
But it has no assets, according, as I understand the proof was.
Two points about
love
that.
these judges.
This provision doesn't say assets owned by Physicians Regional. I think the way to harmonize, to read the contract as a whole, that provision, it's not nonsense, it's not absurd. Of course there were assets at Physicians Regional. There were hospital beds, lab equipment, surgical equipment. And if those assets were transferred, that would trigger this provision. That would trigger the assets provision. Your Honor, Chief Judge, look at C, 5.4C. That's the specific provision that Ms. McCain invoked her right to resign, terminate without cause. 5.4C says cessation of all material operations of employer and or hospital. So that's the provision that's at issue in this case. Cessation of material operations. The operations at Physicians Regional did cease. They did cease, and you don't have to just take my characterization on that point. HMA itself used that very language in the notice that was given to Ms. McCain.
This guy
That
is
notice-
awesome. He knows how to work a mic.
That Judge McClarty already asked about.
I like how he smiles
Which is
and,
in the
like,
record,
looks at an
page
agreement with the
384
judge,
in the
like he's
record.
over there sitting playing Sudoku.
It says, please note that all
That's why you're here.
operations at our physicians' regional medical center location will permanently cease. It uses the very language in the termination provision, and that's HMA's own form. None of
This
this
guy
is
went to church on
absurd.
Sundays.
Yes, it had assets. Yes, its operations could cease. And HMA had good reason to define hospital. To put it simply, Miss McCain needed to know where to
He
deliver
does it.
babies.
Could you imagine?
This agreement requires her to admit patients at hospital with a capital H. It requires her to provide on-call coverage at hospital with a capital H. If not for the
You
cover
ran
sheet,
the helicopter at the
she
hospital.
wouldn't know
There's a capital H.
which of the hospital campuses to send the patient to. So
Well, sorry, Matt, one time
HMA
drove over
had
the,
good
hospital
reason
and got
for this
by accident.
definition. She delivered babies, she admitted patients as required by her contract at the
She'll be landing pad out in the
hospital
parking
known as Physicians Regional Medical Center. The fact that it was a hospital, the three campuses did have one state ID number. So they were a hospital, one hospital for that purpose.
Hey,
That doesn't
how you doing?
mean that they still weren't separate hospitals. And HMA knows this. At the
this is
deposition of their
Tennessee
corporate
Court of
rep,
Appeals
Tyler Sherrill, he was asked,
case.
Mr. Sherrill, you
no,
understand
contract
what
law.
I mean by Physicians Regional Medical Center, do you? And he said without hesitation, the hospital in downtown Knoxville, people still call it St. Mary's. That's what we're talking about, St. Mary's. So this,
There you go, Ballstorm.
the argument here, not only does it conflict with the plain language, it conflicts with the way HMA itself used these names. So let's talk about the bylaws.
Hey, Miami, St. Mary's. is
They
where,
don't
Peyton
define
Manning
hospital. They don't trump
Get his knee done.
the definition in the contract. Yes, Physicians Regional had bylaws. They had one set of bylaws. That doesn't mean that all three hospitals, all three campuses, that doesn't mean they didn't have bylaws. HMA's argued on appeal, well, they didn't have an independent set of bylaws. So, it had bylaws. And those bylaws treat the operations
St.
at the
Mary's out
different
on Broadway,
campuses
too, I believe.
distinctly.
Or used to be.
In the bylaws themselves,
lost in that one.
2 examples. Medical providers had to apply for admission to staff at each campus. So if these terms, what HMA has argued on appeal is, well, this is an assumed name, you got to treat them as interchangeable. That has never been the case in HMA's practice. That has never been the case. Doctors and other medical providers had to apply for privileges at each campus. And you could have separate practice status, different status at different campuses. That's one example. Also,
Jungle Mix,
each
it was
campus
spinning
had
earlier.
its own CEO, CFO, and chief nursing officer. So HMA itself did not use the names of these locations interchangeably. There is no evidence in the record that HMA ever used the term Physicians Regional, the name Physicians Regional Medical Center, to refer to anything else but the hospital that many of us know as St. Mary's. That's the location we're talking about.
There's no H.
HMA itself used
St.
that
Mary's.
name for one location and one location only. And HMA itself chose to use that name to define
Yeah, but
hospital
you know it.
with a capital H in this
I
agreement.
respect the bow tie on
Board of
attorneys.
directors,
I think
another
it's cool.
argument
I like
that
the bow
HMA
tie.
has made is that
It needs to be
Physicians
says
Regional
something
didn't
about
have
the
a board of directors. Well, it did. All 3 campuses had a board of directors. One board for all 3 campuses. And the board, and this is defined in the bylaws, the board is specifically defined as the advisory board of Physicians Regional Medical Center. It's referred to in the bylaws. Similar point. Again,
how HMA itself used these names. The contract required Ms. McCain to get medical and staff practice privileges at all locations. So in accordance with her contractual obligation, she would submit application forms prepared by Tenova or HMA, and she had to separately check where was she applying. Physicians Regional, Turkey Creek, North Knoxville. Separate check for each one. And when HMA approved her application, they did so by letters that were signed by each CEO with a separate signature block for each location, for each hospital campus. A CEO for Physicians Regional, for North Knoxville, for Turkey Creek. The point is that HMA itself never used one location name to refer to a different location. It never did. Not in the contract itself, and not in the documents that the parties used when they were performing their obligations under the contract. One more point on the assumed name. The fact that a company has an assumed name does not mean that if it has more than one assumed name, the names are interchangeable. That's not what the assumed name statute is about. That statute applies if someone's trying to hold a member or owner personally liable for an obligation of the LLC. And let's say they were operating under a DBA or assumed name,
about the four
they get
corners of
sued
the
personally. They
contract?
say, well, no, wait a minute. That was LLC. We were doing business as an LLC and we have a registered assumed name. The point is that using a DBA or an assumed name doesn't strip a member or owner of that liability protection. But that protection has nothing to do with the way that an entity with multiple assumed names can choose to use those names. This isn't about trying to pierce the veil and hold the members of Metro Knoxville HMA LLC personally liable. So the fact that it was an assumed name has no legal significance
next case starts
in this
in
appeal.
5 minutes.
None whatsoever. It would be as if
5 minutes.
Copper Seller Corporation hired somebody to work at Chesapeake's. Assumed name. That person can't say, oh, Chesapeake's is an assumed name. Oh, I want to work at Calhoun's as well. Assumed names don't work that way. That's not the way that HMA used them. So our position is that when the contract is considered as a whole, including its definitions and its capitalized terms, and by all means, including the bylaws, when it is considered as a whole, it's clear that the definition of hospital as Physicians Regional means the hospital location known as Physicians Regional, which used to be called St. Mary's. The trial court's judgment awarding 2-month severance should be affirmed. Thank you.
Thank you. Here from the appellant rebuttal.
I mean, this is a lot. It's got to be a ton of money, right?
Your Honor, just a few points.
To bring up to appeals.
We've heard a lot of argument about separate locations, and we certainly don't dispute that there are separate locations. The issue in this case is not whether there are multiple locations. Of course there are. But multiple locations does not mean there are multiple hospitals. And as counsel said a few times during argument, Physicians Regional, that's the location we're talking about. We don't dispute that Physicians Regional is a location of the hospital. That does not mean that Physicians Regional, by the terms of this contract, when you read it in its entirety, is the hospital. It is simply one campus, one location of the hospital. Ms. McCain has mentioned the cover sheet, and the trial court made a significant issue about the cover sheet. I would just like to note that the cover sheet is simply one part, and as we've said, the cover sheet lists Physicians Regional, which was an assumed name, and I do think there is a legal relevancy to an assumed name here. The assumed name is of the hospital, HMA. The fact that different campuses used different assumed names is irrelevant. It doesn't matter, you don't have to interchangeably use Physicians Regional and Turkey Creek. That doesn't mean that Physicians Regional is not HMA or that Turkey Creek is not HMA. But more importantly, with regard to the cover sheet, there is a provision in the employment agreement that says where the terms of the cover sheet, this is section 1.1, where the terms of the cover sheet conflict with the agreement, the terms of the agreement prevail. So I think we have to look at the entire body of the agreement and what the parties intended. When you try to
Yeah, she
get
intended
at
to
what
get
the
2 months
parties
severance.
intended, then you have to look at all of the facts and circumstances. And I agree, it is of significance to look at the notice that was given to Ms. McCain. The notice did not say there would be a cessation of operations of the hospital. The notice said there would be a closure of the Physicians Regional Medical Center location of the hospital. Also, there's been some discussion about privileges. I think it is important to note that Ms. McCain applied for, and this is in the briefing, she had privileges at different campuses. That doesn't mean the different campuses were different hospitals, but she did have privileges. So when one campus closed, she kept her privileges at the other campuses. And perhaps more importantly, her employing physician, she worked for Dr. Brabson, and Dr. Brabson, in his statement, the employing physician statement said that he would be responsible for her actions at all of the campuses and lists the different campuses.
This one's in Knoxville.
Now, I don't pretend to know where she actually did work, but she agreed when she entered into this employment agreement that she would be working at all of the campuses, and Dr. Brabson affirmed that she would be responsible for patients at all of the campuses. Finally, there was reference to the bylaws, and I guess we do agree the bylaws are instructive. We just disagree as to the conclusion that should be drawn from the bylaws. If you look at the bylaws, in one provision, I'll use this for an example, if you look at all the references in the bylaws to hospital, and instead of us using the word hospital, accepted counsel's argument and used the term Physicians Regional. The bylaws say that the individual must maintain a staff category at each campus location. It does not say at each hospital. If plaintiff's argument were correct, it would say, the bylaws would say hospital. The bylaws require that different committees be formed and that the committees include members from, quote, each campus location. It does not say committee members from each hospital. The bylaws say physicians may have a different status at each campus location. The bylaws do not say a different status at each hospital. And for those reasons, we ask that the court look at the entire agreement, and given the entire agreement, consider what did these parties intend when they entered into this employment agreement. And it is very clear that they intended that hospital be a 3-campus system as they knew and understood it to be. For those reasons, we ask that the court reverse the decision of the trial court.
Our thanks to counsel for both sides for your briefs and your oral arguments.
All right, so there you go. That was a contract.
We all make garbage, and humans throw out 2 billion metric tons of it every year.
And choose that. Nobody cares about your flip-flops. What we do care about is the next case coming up is Diane Murillo versus Branch Baking and Baking? Did I say baking? I got the baker on the brain. All right, here we go. But they don't play around here, do they? Thought y'all like that.
Represent the appellant, Diane Morello. And I would like to reserve 2 minutes as rebuttal, but probably won't need it for this type of case.
That'll be fine.
Okay. So what we're here on is a single issue. We filed this brief because we believe the trial court abused its discretion in denying my client, who was pro se at the time, Her motions
Yeah,
for
Maha, how you doing,
continuance
bud?
to allow my client
You
to
doing all
obtain
right?
new counsel after a previous counsel had withdrawn off the case. Now, what we believe the legal standard is that
Tennessee
when
Court of Appeals in
counsel
Knoxville
withdraws
meeting
off the
for
case,
everything,
it's the duty of the court to continue a case a significant length of time to permit the defendant or to permit the litigant to try to obtain new counsel. Now, what we do admit is Mr. Arthur withdrew from this case in 2021, and motion for summary judgment wasn't until 2022. So there was a year in between the withdrawal of counsel and the motion for summary judgment that BB&T filed. Now, I think the facts that are relevant in this case was that my client testified at her motion for continuance that she believed
Does
that
the
the case was
BB&T
taken off the
is,
docket. And I
case-
think whenever you tell a client or tell a pro se litigant that a case is taken off the docket, a pro se litigant may not know what that means. However, when the motion for summary judgment was filed on November 14, 2022, or November 7, 2022, my client did try to obtain new counsel as fast as she could. She ran into a few problems when that happened. First, it was Thanksgiving, around Thanksgiving time, so she called some attorney's office, they weren't in. She called some attorney's office and they were conflicted with the case. So she wasn't able to obtain new counsel by the time the motion for summary judgment and her motion for
I thought
continuance
y'all
was
would enjoy
held.
this. This is
However, she was
appellate
able to
stuff.
hire me before.
knows there's nobody in the courthouse.
It
no
was after
juries.
the final judgment, but before time ran out to file the appeal. So what we believe is she wasn't given a reasonable time, and the trial court abused the discretion not to allow her to obtain new counsel between November 7, 2022 and the time that the summary judgment was heard. And we would want the case to be remanded for the motion of continuance to be granted, or to hear the motion for continuance again, and to rehear the motion for summary judgment.
Counsel, when was this case initially filed?
Initially filed May 24th, 2011.
And when was the motion for summary judgment filed?
November 7th, 2022. And she had counsel from May 24th, 2011 with Arthur Knight. He did withdraw off the
Art
case
Knight.
in 2017, but he got back on the case. And then he withdrew again in November of 2021. Now, from my review of the record, I don't know if there was an actual hearing for his withdrawal or if it was just an order sent to the court.
When did the judge rule on the motion for summary judgment?
December of 2022. So it was right after the 30 days from the November 7th.
It had not been continued from the initial time it was filed?
The initial motion for summary judgment or the initial filing of the case?
No, the initial motion for summary judgment.
So, no, this was the first setting for the motion for summary judgment. That had not been continued. It was filed November 7th of 2022 and then heard in December of 2022.
At counsel on November the 7th.
She did not have counsel November 7, 2022. She had counsel in November of 2021, and he withdrew. So between November of 2021 to November of 2022, she did not have counsel. Where she got confused is she was told the case was, she testified to this at the motion for continuance. She was told the case was taken off the docket. So she didn't try to get counsel between November of 2021 to November of 2022. But after the motion for summary judgment was filed, she did immediately try to get counsel, but could not get counsel by the time the motion for summary judgment was heard. And then she did eventually get me a few weeks after the final judgment was entered.
Oh, boy.
Thank you.
You have your time for rebuttal. Hear from the appellee.
Please, the court, Morris Kaiser, I represent BB&T in this case. As Mr. Long said, the case was filed on May 24, 2011, amended complaint on August 10, 2011, and arises out of a dispute with the sellers of lots to Mrs. Murillo, some lake lots at Norris Lake Development. She claimed the sellers committed misrepresentations and fraud and so forth in connection with amenities, the nature of the lots, the value of the lots. BB&T financed her purchase in part. She agreed to pay $1,012,000. BB&T financed about $815,000 of that. Interestingly, she alleges in her complaint that the bank was also misled by the misrepresentations made by the sellers, particularly in connection with what she claims the sellers misrepresented about the value of the property. She alleges in her complaint that she learned of the misrepresentations of the sellers in 2005, and she alleges that she filed a federal court case against the sellers in 2007. And the record is that complaint. In comparison of that complaint with the complaint she filed in this case, she alleges the same causes of action against the sellers. She alleges that she renewed the note yearly and that she made payments on the note until 2010 when she was not able to make payments after that due to illness. The bank foreclosed on the properties under the deed of trust that Ms. Murillo signed to secure the payment of the debt, and it had filed, and the bank did file a counterclaim in the case for the deficiency judgment. That's just a background on the facts. Now, Mr. Knight, her lawyer, who filed the case for her, withdrew on August 2, 2017. And then he got back into the case after that. There was a notice of a trial setting that was filed with the court on August 19, 2021, setting the trial for December 13, 2021. And these are facts that I'm informing the court of because they're relevant to counsel's statement that she didn't understand about the case coming off the docket. So the case was set for trial, notice August 19, 2021, trial date December 13, 2021. Then November 16, 2021, Mr. Knight withdraws again. Then on November 24, 2021, because I had witnesses who were not available to be at court, I filed a motion to continue the case. Ms. Murillo did not object. Of course, she had just lost her lawyer, so she did not object to it. The case was continued, and I'll speak to that here in a little bit, but on November 7, 2022, on behalf of the bank, I filed a motion for summary judgment, and it was set for hearing on December 12, 2022. So at the hearing, Ms. Murillo did write a letter to the court asking for an additional 90 days from and after the date of the hearing of the motion summary judgment, which would have taken it into mid-March of this year. At the December 12, 2022 hearing, and counsel said she testified. That is not accurate. She did not testify. She made statements. She appeared telephonically. She's a resident of New Jersey, but it was not sworn testimony.
I was going to say
she said, referring back to December 2021, she said, I did not have an attorney at that time. And yes, at that time, I was trying to look for an attorney. And she's referring back to December 2021 at the point in time when the case had been continued. And I made the statement to the court at that time that Ms. Murillo had left me a voicemail message back in December of 2021, acknowledging that she needed to get a lawyer and that she would be engaging with Mr. Knight and trying to find a lawyer. The trial court heard her motion to continue initially, and at the conclusion of the argument, the trial court said, ma'am, you have had the responsibility to prosecute your case and move it forward. It's now 11 years old plus, and we're going to go ahead. So the trial court denied the motion to continue the hearing on the motion for summary judgment. Then considering the motion for summary judgment, the trial court concluded and stated there are no allegations in the pleadings about fraud relative to BB&T. So the court granted the summary judgment, which was brought not only on the original action, but also on the counterclaim. The only issue raised on appeal by Ms. Murillo is whether or not the trial court abused its discretion in not granting the motion to continue. There's no there's no issue raised as to the correctness of the motion for summary judgment or as to whether or not it should be set aside.
And they went belly up.
Of course, the standard for abuse of discretion is clear.
You started selling these properties
I don't
at
want to
auction.
belabor the point except just to mention briefly.
You don't have an opportunity to
And
inspect
before I
the
do
property.
that, interestingly, in a
This
case
woman
cited by
assumed
Ms. Murillo in her
They had all
brief,
these amenities like they have in New Jersey.
Memphis Board of Realtors versus Cohen, the case
Got $1
says
million
there is
in
no
New
absolute
Jersey,
right to
bought
counsel in a
Tennessee,
civil
bought the
trial.
property, and then one day she decided
And then,
to
of
go
course, on abuse of
vacation, see
discretion
their property.
in connection
Gets there
with
and
the
she
grant
sees
or denial of a motion for
woods.
continuance, that action will not be interfered with unless there's a clear showing of abuse on the trial court's part. It's
So she
Tipton
tells the
versus
bank,
Smith
well, I'm
case
not
in my
paying.
brief.
Bank
The
says,
court
"You owe us
in
$800,000.
Carroll versus
What do
Henderson
you
went
pay up?"
further and said there has to be a clear showing of gross abuse in connection with a motion for continuance. And
She's an
then,
attorney.
also
and the attorney has
instructive
problems.
is the case Old Republic
her.
Life Insurance Company, again cited in my brief,
I don't know. I'm not gonna
but
say
two
that.
significant statements in there, those being, a trial court's ruling will be upheld so long as reasonable minds can disagree regarding the propriety of the decision made. And the abuse of discretion standard does not permit the appellate court to substitute its judgment for that of the trial court. And the court went on to say the appellate court should begin with the presumption that the decision is correct and should review the evidence in the light most favorable to the decision. Now, another aspect of it is that in addition to needing to show that there was an abuse of discretion, the appellant also has to show that there would have been a defense, there would have been a reasonable chance of a different outcome if the motion had been granted. And that's the case, State versus Hurley, cited in my brief, that says the complaining party must show that a different result might reasonably have been reached if a continuance had been granted. Now, at the hearing, and it's the transcripts in the record, Ms. Murillo says, well, I can get affidavits about what BB&T people said and so forth. Well, maybe she could, maybe she couldn't, but the reality is the court granted summary judgment only on one of the grounds that BB&T asserted in its motion for summary judgment. Among other grounds asserted by BB&T was ratification, and that is that misrepresentation, a plaintiff can ratify misrepresentations and fraudulent statements by their subsequent action. And in this case, Ms. Murillo says she learned about it, the seller's misrepresentations in 2005. She asserted a lawsuit against the seller in 2007, yet she continued to make payments on this note until 2010 when she said she was no longer able to make payments. And certainly that would constitute ratification. My point being that even if she could have brought in affidavits and put at issue something that a BB&T representative said or didn't say, the reality is there are other grounds in the motion on which the court could have granted summary judgment, and ratification being the probably primary one. So my position or my point on that is, even if if your honors think that the trial court should have granted the motion to continue, Ms. Murillo nevertheless failed to demonstrate that she had a reasonable, to quote the language, that a different result might reasonably have been reached if a continuance had been granted. Now, I also want to speak to counsel's statement about Ms. Murillo saying that she was told the case had been taken off the docket.
Oh, taking off the docket. That's a big one.
At the hearing in December 22, she said she was told in a phone call that by the clerk and master, and that she also got an email from me. And she did get an email from me. It was sent in December 2021 after the court took the matter off the docket. And the email said, and she was pro se at this time, and the email said, Ms. Murillo, the judge's assistant confirmed today that the case has been removed from the docket and it will not be tried on December 13. If you have any questions, please give me a call. I did not hear from Ms. Murillo on that, but it's clear that the comment that the case is on the docket was in the context that it had been set for trial, a motion to continue had been filed, that motion had been granted, and the case was not on the trial docket. I don't think there's anything in there from which Ms. Murillo might reasonably be able to say that she believed the case had just been set on some kind of inactive docket to sit for a while. So I don't think she could reasonably do that. But again, we have a situation where for 13 months from the time Mr. Knight withdrew in November of 2021 until the hearing on December 2022, and acknowledging at the hearing that day that back in December 2021 she knew that she needed a lawyer. She nevertheless did not get a lawyer. And the trial court said, you know, this thing's been pending 11 years and it's time for this case to move along. And respectfully, Your Honors, under the standards for abuse of discretion, particularly those that I just read, I think that the trial court clearly exercised. I don't think her decision can be challenged on an abuse of discretion standard or otherwise. So I think she clearly made the correct decision on that motion to continue and clearly made the correct decision on the motion for summary judgment, although that is not at issue, was not raised in this issue on appeal. Thank you.
Here's the appellate rebuttal.
Just 2 things. First would be, it is true that a pro se litigant does not have an absolute right to counsel, but this case is different because in this case, she did have counsel. What we're talking about is when counsel withdraws, is it an abuse of discretion not to get a reasonable time to obtain new counsel? So there's a slight difference between those line of cases that says you don't have an absolute right and a case where counsel actually withdraw to get a new counsel. And the second point is about whether or not there's a reasonableness of a different outcome. Well, the reason why you would need to get new counsel is to investigate the facts, which Ms. Murillo didn't have because she wasn't able to get new counsel. So she's not going to be able to present any of that type of evidence as a pro se litigant to show that there's going to be a reasonableness that the motion for summary judgment would be overturned. So that's why you need to get new counsel to investigate the facts and find possible affidavits for the motion for summary judgments, find possible evidence that the pro se litigant says is out there in order to defend the motion for summary judgment. So that's why I believe that it is abuse of discretion that her motion for continuance was not granted, and I believe it should be remanded to overturn that and bring it back to the trial court.
Our thanks to counsel for both sides. Appreciate your arguments and your briefs on this. If you would, adjourn court till tomorrow morning at 9:30.
All right. You say adjourn till tomorrow morning? Well, there you go. So what do y'all think? You like the, you got 3 cases in today. Where's my thing at? You got 3 cases in. Appellate court. That's how it works. In and out. You got to have your stuff together and you got to get ready to go quickly. Hang on a second here. I'm checking my, I don't even think it's a house fall storm. I think it's that property, you know, they had a lake property. This is probably like a farm, okay, at one point that they bought. A developer comes in, buys a farm for like $2 million, right? More money than the farmer's ever seen. And it's all along the lake, a lake that used to be a creek that the TVA came in and flooded. So now it's like, oh, it's big money stuff. 9:30 tomorrow morning. All right, I'm gonna try to be here for it. I'm gonna try to be here. Hopefully my day is good. Yes, I thought you guys would enjoy it. I mean, it's a quick little turnaround. You get important stuff out of like appellate court process. And it's kind of interesting, like the one where the like this one was interesting to me because of knowledge, and the other one, two out of the three, I kind of knew some of the people involved, so that was kind of cool for me. Surprise! So not all surprises are good. But it's a refreshing thing. It's I don't know how often they do these. It's like usually like every several months. You know, it's like the U.S. Supreme Court. They only meet every so often. But yeah, I try to do this in the morning. The tiny terrorist keeps pushing poor Odie every time he's getting ready to do his thing. That is hilarious. Oh, that's hilarious. Oh, that's good. That's good. Anyway, so there it is. Got your afternoon little your nooner. Trial nooner. Get relaxed. Get have fun stuff. The guy with the bow tie was cool. That was a contract dispute, and that used to be St. Mary's chain of hospitals. And that was Peyton Manning used to be associated with them. If you guys know who Peyton Manning is. Yeah, it's very different. In Tennessee, you can only appeal something that's been brought up in court to appeal. So it is, if Tennessee likes to stay on the side of the trial court. But, you know, what the last case, the BB&T? I'll let you guys know. I can see. I'll have to. I don't even think I've never thought about getting on the Supreme Court stuff when they put out opinions. It's almost 8 p.m. Oh my gosh, you're 5 hours ahead. I got a lot of stuff to do between now and 8 p.m. Oh, that's cool, Trish. My son was born at St. Mary's. Yeah, I know somebody else who had a child born at St. Mary's. Yeah, but you know me, I'm always lurking. I don't know if you're lurking, I don't know. Oh gosh. Anyway, guys, what else is there? I don't have anything for the afternoon. Okay, so I'll tell you this. It's catch-up time at the Hacienda. We have a fabulous Samsung refrigerator that has a evidently what the problem is that the ice makers, when they're put into the refrigerator section, you need the ice maker to be in the freezer section, the bottom. The ice maker eventually will freeze and whatnot. Anyway, our refrigerator has been frozen for a while, and we've pretty much been using it as a cooler. Taking frozen ice out and put it in the fridge, make sure our stuff stays cold enough. Been going like that for a year. Great, right? Trailer park type stuff there. Anyway, we have finally gotten to the point where we thought that's when I say like I don't have time. Think about not being able to have the amount of time to just unplug your refrigerator. Just unplug it and let it thaw out. I haven't been able to do that for over a year. So anyway, finally got it done. This morning, so like we really literally have everything in coolers right now. Woke up this morning, saw it's like, oh, awesome. Start taking stuff, the shelves out and everything, doing the big cleanup. Got to put it all back in and turn it back on. Got to do that this afternoon. Got to mow the yard this afternoon. I got to check on my mom this afternoon. Right now, the White Rabbit is checking on her dad. And we are running a 3-ring circus. But I wish I had a lion. because I'm at the point where I'd stop feeding the lion and he would start thinking I would look tasty. I'd be like, okay, come get me. I'm done. Anyway, what a way to go, right? Have a weed nap, rest your mind. I appreciate that. I need to. I overslept today, though. I didn't expect today to happen. Woke up and I'm like, whoa, what time is it? Brown Dog is like a alarm clock. And I need to get up when he tries to get me up. He got me up this morning. I thought it was too early. I'll tell you one thing. These blackout curtains, first got them, it was hard to sleep. Like, not sleep, but it's like waking up, like everything messed me up. So now I sleep with them open because I got to have that cyclical rate. Stick a fork in me, I'm done. Yeah, I've got a Samsung. Here's the problem, okay? They don't make refrigerators in America anymore. And foreigners don't understand why we have such big refrigerators and why we like ice. You know why I like ice? Because I won, damn it. It is my birthright. Ice makes everything better. It melds the drink. You can't have very certain cocktails you cannot have without ice. Boy, I tell you what, you open up a Coca-Cola and you pour it over that ice and it releases that carbonation. It brings out all the flavors of the drink. And then it slowly melds. As it melts, the conversion of the temperature difference and the little bit of water that comes off the purified ice melds with the flavors, the caramel flavors of the cola. And it makes it so tasty, so delicious. It's the perfect way to be served. I like my ice. That's why we won World War II. Was to have ice makers. It's all over the ice makers. Anyway, oh, that's bad. That's real bad. Yeah, ours, there's a thing on YouTube on our refrigerator. I've done this like 3 times. Problem is, last night I didn't have time. So it just got worse and worse, and to the point where our ice maker froze up all the way. Like, there's a huge block of ice, one solid block of ice. Yes, I need ice. I don't want room temperature stuff. I just, dog scratching. I even like, bottled water to be cold, and then I let it warm up a little bit. Get a few degrees below room temperature. Anyway, that's all I got. I gotta go fix that. What is happening over here? And then I'll be back later. Guys, it's supposed to. It's supposed to. Dude, this is a top of the line Samsung. We got it when we moved into the house. White Rabbit's dad got it for us as a present. I mean, if you... It's a sin how much this damn thing cost. They just can't figure it out, man. Just can't figure it out. Talking trash and truths. You're so mean to me. You're so mean. Kitty fund. Kitty fun. Fund. Kitty. Kitty. Kitty, 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 kitty. We've got to move before we can get anything. What are you doing? I don't have anything cool. I don't have any more. I don't have anything cool.
Come on, bark like a dog for me. Come on, bark like a dog for me. Come on, bark like a dog for me.
I don't know what the arf is. I think everybody wants to be Hillary Clinton. So, but for you, my dear, my love, where's this stupid ass damn thing? I gotta clean up all these things. I don't have time. I don't have time. I need the patience of strangers. Teeth, are you nut? Oh my gosh. Hey, Eris, how are you doing? I don't understand. I come in, I start seeing arf. I'm like, what are you, like Hillary Clinton over there? Barking like a dog for me. People shouldn't come into my chat and not include me on the joke, because I'll just answer it the way I think it is. Bark like a dog for me. Oh, jeez. Thank you. These are the Tony Stark sunglasses from Amazon. I kid you not. Like, what was it, Spider-Man 6, 5, 10, 9, whatever. Homecoming, Go Home, Sit at Home. What are those Spider-Mans? Tony Stark was there. It was these sunglasses, but I think they had a blue tint to them. Helen back, how are you doing? Oh my gosh, Helen back. I hope you're doing well. Oh my gosh. Guys, thank you for coming here this afternoon. I gotta go cause trouble and mischief, so I have something to talk about tonight. So, remind me what I'm doing, and I'll I don't know what I'll do. Do I do it?
Well, I woke up to go get me a cold pop, and then I thought somebody was barbecuing. I said, oh Lord Jesus, it's a fire. Then I ran out. I didn't grab no shoes or nothing, Jesus. I ran for my life. And then the smoke got her. I got bronchitis. Ain't nobody got time for that. Ain't nobody got time for that. Ain't nobody got time for that. Ain't nobody got time. Ain't nobody got time. Ain't nobody got time for that. Ain't nobody got time for that.